on 89.9 in Lusaka and the surrounding areas. We are also live on our partner radio stations, Tuta FM in Mansa, covering Rapula province. Thank you very much for tuning in. That is on 90.7 FM. We are also live on iWave FM in Chingola, covering the rest of the Copper Belt on 90.1 FM, and also live in Muchinga on Muchinga Radio and covering Muchinga province on 88.1. Spice FM in Kabwe, covering Central Province as well on 91.1. And we are grateful that you are actually tuned in this morning. Don't forget, we are also live on our Facebook page, and that's 5FM Radio Zambia, and our YouTube channel as well. And I should be able to also make mention that we are live on Grindstone TV. We are also live on PF as well as Smart Eagles channels. I'm your host, Zachariah Banda. Welcome to the program today. Our guest is Lusaka renowned lawyer in Makebi, Zulu. He is in the house to have a conversation with us on a lot of burning issues. Counsel, welcome to the program and good to have you.
Thanks for having me, Zach.
How have you been?
I've been happy. How have you been?
I've been well as well.
I can tell.
About being happy, not very sure, but I have been well.
That's the only thing you have a choice over.
Obviously, I'm usually saddened because, so many burning issues. And the more we have burning issues in the country, I get sad.
That's very sad.
And I hope we can talk around some of them this morning.
We should.
Thanks for coming.
Thanks for having me.
Right. So let's get down to a conversation first and foremost. The Patriotic Front, 9 members of parliament that obviously got their suspension from parliament, or actually them having acquired a stay and they are back in parliament. But then there was a debate around it in the sense that the deputy speaker was questioned in the decision that obviously he made around declaring those seats vacant. Again, there was a lot talked about in terms of the fact that there was an active case in court at the time he was making that announcement. Where are we? What is likely to be the argument now that you have stated that, as well as the fact that it needs to be argued in court?
I think the first thing we need to address is the problem that we have in the National Assembly. Signs of this problem started way before, when the Kabushi and Kwacha seats were declared vacant, unlawfully so, by the Speaker of the National Assembly, where there was a matter that was pending in court. You will notice that there was a time when matters were in court after the High Court had declared the seats or had ruled against the persons that were involved in those petitions, and the matters had gone before the Constitutional Court. The Speaker went against all parliamentary precedents, went against the law, and said, you can't come to the National Assembly. Now, that is something that has never happened. In that previously, there have been petitions and people were going to National Assembly because the National Assembly follows the sub judice, others will say sub judice rule, which means that if a matter is in court pending determination, you can't make a decision over the same, because the decision of the court you may have decided. So you wait, you don't make any. What did the Speaker do? She made that decision, and the court said, no, you can't do that, because merely by a person appealing means that the status quo is maintained for purposes of maintaining that balance and awaiting the determination of the court. So her decision was reversed as regards that. Then we had an incident where Miles was expelled from the Patriotic Front Party. The speaker came and said, yes, you have raised this point of order that he has been expelled from the party. In the case of Chishimba Kambwili, the court held that I cannot interpret the constitution, and therefore I am unable to declare the seat vacant because I will be interpreting the constitution in doing so. So I will not. That is what happened. Then the next thing, we had the purported expulsion of the 9 MPs. What did they do? The speaker goes ahead and says, no, 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 you were expelled from the party. Your matter, at that particular time, the matter was in court for all intents and purposes. The speaker goes ahead, interprets the constitution and says, get out of here. You can't be here. Now, that is
first of all,
delving into the interpretation of the constitution, when previously, yes, when it's related to someone else, they said we can't interpret the constitution. Now we have the latest event of yesterday, where the speaker goes and interprets Article 70, clause 2, F, and says, well, because of this provision, the Kawambwa seat is vacant. But this is a matter where the person in the Kawambwa seat or holding the Kawambwa seat has since appealed the decision of the subordinate court and has since applied for bail pending appeal. Now, you have all this going on, and you find that we no longer have speakers that are trying, at best, trying to be impartial. We have a National Assembly that is serving the interest of the executive. We have a problem in this country because now we have the executive, the judiciary, and the legislature singing from the same hymn book. Everything is choreographed to perpetuate the stay of the UPND in power, and that shouldn't be the case. It is in the interests of a democracy that there must be a balance of power. A balance of power requires that the judiciary is independent, the legislature is independent, the executive is independent, and they check on each other. In checking on each other, they have to ensure that the other is doing the right thing, not being complicit in the wrong decisions that are being made by the other arm of government. The moment that happens, there's no longer confidence in the systems. There's no longer confidence in the so-called rule of law, which is being preached about every day. And the country may degenerate into chaos because people will no longer believe in the systems that we have set up for ourselves to be a check on how we address things or how we approach situations. It is expected that there must be certainty in the sense that when I am going to go to court, I should be able to know that if the court ruled a certain way in a particular matter, they will be consistent to rule the same way in this matter. If there was a ruling that was determined earlier in the National Assembly that was ruled in a particular way, where there's a different subject and the facts are similar or the same as the previous one, we expect that the ruling should be the same. But we have a renegade speaker in there. We have a renegade people that are presiding over the business of the assembly, who are only pandering of the executive, and what the executive wants goes. And that should not be the case.
What
we
are you
eroding our democracy?
What are you basing your objection to the speaker's ruling yesterday
I
on?
have given examples. Look at this situation.
What does the Constitution say?
The Constitution,
in the case of
yes,
yes,
the Constitution provides that a person who is serving a term of imprisonment will obviously lose the seat. But this is a person that has since appealed, meaning that there's supposed to be a determination as to whether the conviction was correct or not. In the event that the High Court says that the conviction was not correct, it means that this person has to be reinstated. But if you are going to chase this member away from the National Assembly, it means that that damage cannot be undone. It can't be undone. It is for that reason that even in the case of Cheshimba Kambwili, the court insisted that where a matter is in court, it is important that the National Assembly should be able to consider that this on matter they can't move because it is awaiting a determination of a court. The moment they move, they are seemingly saying whatever the court is going to decide doesn't matter. We have made our decision, and that should not be the case. Hence the sub judice rule that that Parliament has conventionally followed over the years until Nelly Muti became Speaker of the National Assembly. That should not be the case.
It's a debate that has brought out a lot of scholars trying to defend the decision of the speaker. The speaker yesterday had, I think, a debate with Honorable Mpundu of Mkana constituency around the same, where Honorable Mpundu felt that the decision to declare the seat vacant, that is the Kawambwa seat vacant, was rushed because in this case, there is a period of which the convicted has or enjoys the right to appeal. And once appealed, like you stated, but the argument from the speaker is that this is a convicted member who has since started serving the sentence upon conviction. That is the argument.
Exactly.
And she says that's what the Constitution says.
Compare that to her decision where she says, if I'm going to rule, I will be interpreting the Constitution, because she has given an interpretation to the Constitution. Perhaps what the speaker should have done in this particular case is possibly refer the matter to the Constitutional Court. I have this situation before me, and there is this provision of the law. This person has since appealed. What is the interpretation of this particular provision? But she went ahead and gave it meaning, her own meaning, which defies all logic. It defies logic because consistently, National Assembly has refused to delve into matters that are before court. But the last two decisions that have been made by the National Assembly that relate to the opposition have gone against that particular rule. It's for that reason that the 9 MPs rushed to court and said, look at what is happening. The court saw merit in that and said, no, we are going to stay the decision of the speaker until this matter. That is what the court will be doing, determining the matter on its merit, looking at the decision that was made by the speaker. And this decision that has been made over Honorable Nixon Chilangwa for us, that relates to the National Assembly. National Assembly is precluded from making a decision over the same until so determined. That is what we should be looking at. And that is what we should, and the essence of that is for purposes of protecting our democracy. But the UPND has been in a rush to ensure that they obliterate the opposition, they reduce the democratic space that we have, they reduce people's rights to speak and have their own way. They can't have it in this democracy because we'll be taking several steps back. We're supposed to be moving ahead, improving on our democracy, be able to appreciate that there will be diverse views in our community, which we may not agree with, but are bound to protect and respect.
Yeah, and the debate around the Chilwangwa's case is being referred to the Keith Mukata's case. How are the two different?
Now, look at the Keith Mukata case. Keith Mukata was charged with murder. The whole time after
by nature that it was a non-bailable case.
It was non-bailable. Then afterwards, Keith Mukata was sentenced to death.
Right.
Yes. So he was sentenced to death. Having been sentenced to death, it is different from the provision that
So
we're
even
looking.
if he had appealed the case, he was still not going to be available because the case is non-bailable.
No. But in this particular case, he never even appealed.
But had he appealed, was it still not going to work? Because by nature, he will still need to be. He's a murder suspect at that
No,
point.
he was a murder suspect. Then he became a convict
Convict,
thereafter.
yes.
Yes. Then the sentence was not a term of years; it was to death. You see that, but the
Right.
provisions even compare them. It's oranges and bananas.
Hmm.
Yes.
Interesting. Let's then move on because now we have issues around corruption. You know, I know that as a learned lawyer, have really broken your heart in some way that legal minds were at the center of debate in terms of corruption, starting with the Anti-Corruption Commission, where a red flag was raised or a whistleblower talked about it. And later on, State Council Mwenya stated how it was very difficult under his leadership for the board to even be availed of any proceedings or indeed active cases to the board by management of the Anti-Corruption Commission. How is what is supposed to be the proper way of doing business at Anti-Corruption Commission
Okay.
between the board and the management?
The problem at Anti-Corruption Commission began with the president. That was the lamentations of the board to say, listen, there are all these things that are going on. There are deals that are being struck between ministers and the commission, and we are not aware of things. We are trying to get in touch with this DG, but this DG doesn't think is answerable to us because we are both appointed by the same authority. So the moment he reports to Hakainde Chilema, he doesn't see the need to report to us. We are unable to supervise this person. That went on for a very long time. And they got to the extent of saying, listen, the time Gilbert was there, yes, we had problems, but they were better. But with this person who has come, it seems things are worse because this person reporting directly to President Hakainde Chilema seems to stop him from reporting to us. Now, there was a corporate governance issue that was very problematic. The last time I was here with Honorable Haimbe,
Yeah.
we were trying to avoid the same thing when we're saying, do not amend the NPA Act in this manner. You are making the DPP a lame duck. Now, in this particular case, they made the board a lame duck. The board had no power. Their functions were taken away from them because this person says, yes, you are a board, keep meeting, have your meetings, get paid your allowances, I report to someone else. That should not be the case where you have an institution that you've set up to be able to
But that is
investigate
your
independent.
assumption. That is your
It is not
assumption.
my
It may
assumption.
not be what was
It
happening.
is not my assumption. It is a fact. If you listened to what Kaba said, if you listened to what Musa Mwenya said on BBC interview 2 days ago, and if you follow what has been happening at ACC, it is very clear that there's a serious rot, or there was a serious rot, or there still exists a serious rot within the ACC. You have ACC going to the extent of even, I have a particular matter, and I'm very disappointed with Anti-Corruption Commission, where a matter is in court. They are supposed to take certain steps. They don't take those steps. The fraud of the state, they can't do that. The moment they step into that, the belief in our judicial system goes down. And once we kill our judicial system, as has been happening lately, we will see a situation where people will no longer go to court, they'll go to the street. Our desire as lawyers and as a public, as a democracy, is to ensure that faith in the judiciary, faith in the judicial system is maintained. In fact, it must be enhanced so that people know that when we do go to court, we'll get a resolution, a timely resolution, a fair resolution on our matter or favor on the but instead, what do we have? A timid judiciary. We have a judiciary that is wanting to please the state because they have been placed in a place of fear. We have judges that have lost their positions as judges of those particular judges. It's a time as this, where some noble judges, noble people that are there are saying, why are we even here? Maybe we need to go because this thing has gone to the dogs, or maybe the dogs have come to the judiciary. We don't know the nature of influence that the executive is exerting on the judiciary, but so that posterity may be disappointed by the system that was created to serve interests, selfish interests of a particular regime.
I know that we've got a couple an appetite to want to know really what is transpiring going forward. Let's also talk about the eligibility case of the former president. I don't know how free you are to talk about it, or I know it's an active case, and you are a lawyer to it, but feel free to share what you can, and feel free not to share what you cannot.
I hear you.
Yeah.
I know it's a matter of public interest,
Right?
but perhaps just an update over the same.
Yeah.
You may note that we had raised an issue to say, listen, this matter has come before you 4 times, and 4 times you ruled in a certain way. You can't change this time around. The other party comes and argues and says, no, the decision that you made them ignorant of the law, or indeed you failed to appreciate the law, so you can reopen this. They argued that. Then the court looked at our submissions and their submissions and said, okay, the things you have raised in your preliminary issue are the same things that you are arguing in the main matter. We would rather deal with the main matter so that we deal with it wholly. That is the import of what was said in court, to say they want to deal with the matter in a holistic way. So the matter was referred for scheduling. It has since been scheduled. On the 31st of this month, we will be told when the matter will be finally heard and determined on its merits. That is what I can advise. But the arguments on our part are that you have decided this matter 4 times before. This will be the 5th time. You can't change now, because you said he was eligible in the Bampika Palasa case. You said he was eligible in the Danpule case. You said he was eligible in the Sishua case, and the Legal Resources Foundation case. You said he was eligible. Why should he change now? We are arguing that to stand, and our argument has been consistent in the 4 cases, plus this 5th one will continue being consistent with our arguments. And we know that the courts are not like the National Assembly, where you tend to have different rulings depending on who has raised the point of order, or who is involved in the point of order, or who's eating with who. So we do not expect to have such challenges.
Your comment on the happenings at the Anti-Corruption Commission leaves me to think that that could be a replica in many other quasi-government institutions.
It's probable. Look, here's an issue. The Energy Minister, Kapala, was reported to the Anti-Corruption Commission because he cancelled a tender as a minister. The matter was reported that this time around the chickens have come home to roost, and it is very clear that there's rampant corruption in this government. You have issues to do with the FIC trains that there's been an upsurge of money laundering of over 130% from last year. We're at about 5 point something billion. There's now 13.8 billion that has been taken. That is seemingly being laundered through government. And what has happened? The president just issues a statement to say, no, the investigating